We're live. Should we start?
We should be live. I'm going to go ahead and share our page.
I'm trying to log in on my desktop. Let's see. Okay, good. Okay, good. Should we go ahead and get started?
Sure. If you can start introducing yourselves, I will put the link to the closed captions in the. Oops.
Okay, terrific. Hello. Welcome back to Disability Rights Maryland's Facebook Live question and answer event. We're happy to be back after a little bit of a hiatus for December and the holidays. Happy New Year to everybody. My name is Leslie Seid-Margolis. I am a managing attorney for education at DRM, and with me tonight are Megan Collins, staff attorney, Tasha Marshall, our education paralegal, and Susana Barrios, our outreach advocate. So we are very happy to be here with you tonight. I think you've seen from the notes that we are closed captioning this. We also have Spanish interpreting available if you need it. So we wanted to begin by just reiterating a couple of things that we have said in prior Q&As, and then open it up for your questions. I don't think that anybody anticipated that distance learning was going to continue this long into the school year, and so we want to reiterate again how important it is for you as parents and guardians to keep some documentation of how your children are doing. It doesn't have to, when we say data, it doesn't have to be numerical data. It doesn't have to be anything formal, but just being able to log whether your child is making progress, whether your child is regressing, whether your child's staying exactly the same, is really important. And one of the things I think we all learned from the ransomware attack in Baltimore County, which resulted in some loss of data and the inability to produce progress reports for the second quarter, is that information that you have is going to be really important as we come to when students return to school and we come to look at issues of learning loss that kids have sustained, whether there have been violations of their rights, how to begin to put together the services, the makeup services or compensatory services, recovery services that students will be entitled to. So, so just being able to log, is your child participating in distance learning? If so, for how much of the school day? Is it 30 minutes? Is it 3 hours? Is it the whole school day? And what happens during that period of time? Is your child actually engaged, participating? Is your child doing other things, hitting pictures of your child's friends all over the screen? What's actually happening during that period of time? And what do you see happening? Do you see, if your child receives speech and language therapy, do you see progress? Looking at the goals and objectives, do you see anything, do you see things moving backwards? Do you see things moving forwards? And just jotting it down, whether you keep a journal, whether you keep loose leaf paper stapled together, just jotting notes down and being able to go back and look at that when you walk into IEP meetings will be very, very useful. So, so we wanted to just make that point again, and we will continue to make that point because having your own information is really important. So I'm going to turn this over to Megan to see what she wants to add, and then we're going to open this up for your questions.
Sure. So I was going to add, I just put a link in the comments, or I am putting a link in the comments now to a resource from Parents Place Maryland that can be helpful in doing data collection in order to document what you're seeing at home and what your student is able to participate in or what your student might be struggling with. And as Leslie said, there's also a link to the closed captioning in the comments.
Okay, so Tasha and Susanna, do we have questions?
Yes, I was going to point out 2 questions that came in prior to the start of our Facebook Live. And the first question, Leslie, I'm going to give to you, and that is it okay for teachers to demand that the student keep their camera on during virtual or distance learning?
Great question, and the answer is no. Students cannot be required to keep their cameras on, and there are a variety of reasons why that may not be feasible. So, so no, the answer is you cannot be required to keep a camera on.
And is it okay for teachers to have pre-recorded lessons?
It may be, but whether those pre-recorded lessons are appropriate for a child will depend on the child's IEP and the goals and objectives for that child. So we know that there are some students who are not able to access the synchronous learning, and so having pre-recorded lessons that they can access at a later time is working for them. You know, they can't get up in the morning, or they have trouble at that time of the day, or you know, there may be various reasons why synchronous instruction's challenging, but being able to access that at a later time is helpful. But it really depends on the student and the student's individual needs. I think, like the issue with students being asked to turn on their cameras, if a lesson is recorded, it needs to be recorded in a way that does not compromise the privacy of the other kids in the class. So that's an issue that we know has come up and that has been addressed by organizations that are concerned about privacy. So, so they can't, you know, just record everybody in the class and then pop that somewhere for people to look at. That would be a problem.
We don't appear to have any other questions in the comments right now, although if those of you watching have questions you'd like to share, please feel free. We are monitoring the comments section on this video. But in the meantime, while we wait for questions to come in, we did want to talk a little bit about learning loss and the upcoming discussions we anticipate many teams having about extended school year services. And so typically in a typical school year, what it would look like, discussions for extended school year would look at data from during progress reports, students' progress on IEP goals, and would look at potential regression over winter break, spring break, and would look at how a student was able to perform. And as we were saying before, and as we've said in past webinars, since you, the parents at home, are the ones who are really seeing students up close and are in the best position to note any difficulties that they might be having, particularly if it's a difficulty with getting onto the computer in the first place to access instruction. That data collection in this, these few weeks right after winter break, and again when we get to spring break, the data collection in the weeks following a return there will be really important in looking at extended school year. And so data collection is important for parents. It's important for schools all the time, but in this virtual learning, it's important for parents to have that firsthand observational data collection. And like I said in the comments, there's a link to a resource that you might find helpful, but particularly in the few weeks after these natural breaks during the school year, it's important to keep data because when we start looking at the summer, which is obviously a longer break, it helps to know what the trend has been over these shorter breaks in order to determine whether a student really is going to require that extended school year service in the summer. And as I'm speaking, I'm realizing that maybe it would have been helpful to do an explanation of extended school year services before jumping into how to document potential need for them. So Leslie, if I could bounce it over to you to maybe go back and do that explanation.
Sure. So extended school year services are services that extend beyond the school year, and they are required for students with disabilities when the student needs those services in order to be able to continue to make educational progress during the upcoming school year. So if the student has critical life skills on the IEP, and critical life skills needs to be defined broadly, so it's not just functional skills like toileting or speaking or self-care skills, but also critical skills like reading and writing and being able to do math. If a child has critical life skills on the IEP and their progress towards those goals would be substantially jeopardized if they don't continue to get services, then they would qualify for extended school year services. And what we find is that most school systems tend to offer a particular program of maybe 4 weeks or 3 weeks, and it's a certain reduced number of hours. But if a child needs more than that, then the team really does still need to look at extended school year services in an individualized way. So it's possible to take that 4-week program, but then add before and after tutoring or additional services if a student can't go the month of August without services, or needs continuing services. So it really has to be looked at in an individual way. I wanted to focus for a minute, because we tossed around words like learning loss, recovery services, and compensatory services, to just talk a little bit about the distinction that we and we know others are making when we use these terms. So we know that distance learning, during distance learning, IEPs are supposed to be fully implemented. They're just being implemented in a different way because students are not in the classroom. It may be that for a lot of students, implementing an IEP by distance learning does not result in the same kind of progress that the student would make if they were in the classroom. But that's not necessarily, that's not the fault of the people implementing the IEP. It's the nature of the beast. It's the fact that instruction's being delivered virtually. But the team is doing everything that they're supposed to do. It's just the child isn't making the progress you would expect because of the way that the service is being delivered. If that is what is happening, then when students return to school, and there's some kind of assessment of where the child is. There may be your child, there will be a discussion about recovery or makeup services to ensure that your child gets services to try to put them where they would have been had they been in school. So we would view recovery services as those services that will be delivered when an IEP was implemented. It just was implemented in that it was implemented virtually because that's how IEPs were being implemented. Compensatory services have always been the services that kids are entitled to when there has been a violation of their rights. And there are students, many students, whose rights have been violated during this period of time. So we know, for instance, that in the spring, there were some IEP teams that developed learning plans that arbitrarily cut the amount of related services that students were getting. So if your child's IEP called for, say, 2 hours a week of speech and language services, and then suddenly the team said, well, we'll deliver 15 minutes a month of consultative service, and there was no individualized decision, and it just happened, that's a violation. And so your child potentially is entitled to compensatory services for that, in addition to whatever services they may be entitled to because of learning loss. If there are other violations of your child's rights, so if assessments were delayed beyond the timelines, or IEPs weren't implemented, or your child needed something like in-person services and the team refused to consider those because they said, oh, we're not doing that. When a team makes a blanket decision that's not based on your child's needs, that's a problem. So I hope I'm being clear, but the idea behind compensatory services, as we think about it, is that those services compensate for a violation of the child's rights. In learning loss services or recovery services, we look at in a broader way as those services that a student may need because it wasn't really anybody's fault that virtual instruction had to be delivered, but that kids aren't where they should be because of that. So I hope that is clear, and we can explain it more if we need to.
So it looks like we have a question from a viewer who has a ninth grader with an IEP, and the concern is related to whether the student can be failed for non-attendance, as he has been struggling immensely and not learning online. They've only been successful with getting him to attend in the morning, but he's just not available for learning after lunch. And so they're concerned as to whether or not the student can be failed because of that.
So I'll start on this one and then allow Leslie an opportunity to jump in with anything afterwards. But as a first step, the team, the IEP team should meet to discuss the impact that your student's disability is having on learning, whether it's in this case, the student can get online in the morning and can't attend classes in the afternoon, whether a student isn't able to attend to online instruction at all. But the team should consider the individual student's disability, the way that disability affects their access to the instruction, and should discuss options that are available in virtual learning to allow the student to participate. And if the accommodations to virtual learning aren't able to allow the student to participate, then the team should consider whether the student needs in-person instruction. Leslie alluded to that in her discussion of the possible need for compensatory services, that it can't be just an outright refusal to provide in-person services. And so it will be an individualized determination. For some students, the ability to use a virtual one-on-one or have somebody else sign the student into class is sufficient. For some students, maybe it looks like providing core instruction in the morning and paper packets in the afternoon, or for some students, maybe it looks like in-person instruction, but it will really depend. It'll be an individualized determination. And the first step would be meeting with the IEP team to discuss what your individual students' needs are and documenting the extent of your students' needs, sharing any of the data that we keep referring to collecting, and having the team, asking the team how they can meet your students' individualized needs. And we did a pretty in-depth training back in, I think, December. It'll be saved on our page, going into more detail about how to document in a prior written notice what the school is offering to meet your students' needs. And like I said, having data to support what you're seeing at home will be important. Leslie, anything to add?
Yeah, I'm going to add a couple of things. So when we started out this tonight and talked about the importance of keeping data, or keeping records, this is really important when you're talking about attendance. So first of all, I really do have an issue with teams or with school systems that may be utilizing their attendance personnel when what you really have is an issue of whether they're meeting their obligation of providing a free appropriate public education to your child. So if that is happening, we would encourage you to contact our office. But the importance of keeping data is really underscored by this for a couple of reasons. If your child is melting down, refuses to participate, is unable to access education, having that documented, if you keep notes and say, okay, Tuesday, January 13th, 2:00, refused to sign on through the computer, cursed, ran around the house, whatever it is that's happening. If you're keeping those notes on a daily basis, you'll have them, and you'll be able to counter any attendance related arguments that are made against you. The other reason why it's very important to keep notes is that we know that the attendance requirements have been scaled down a lot for kids with disabilities. So kids are often being marked present, but they may only be present for half an hour of a 6-hour school day. And when it comes time to have a discussion about learning loss and make up services and whether kids were denied a free appropriate public education, you don't want to look back at those attendance records and see present when and making it look like a child was potentially there for 6 hours a day, when in fact a child was there for 30 minutes a day. And it was a struggle anyway. But if you have that information, whether the school system has it or not, it will be helpful in making that argument that in fact your child accessed, 20 hours instead of 200 hours or whatever, whatever the number is. So, so being able to say, we do have clients who are keeping that kind of data, how to carry my child kicking and screaming into the room, and she refused, or child turned off the computer, child refused to participate. Whatever's happening, having that will be very helpful, and then you can go into your IEP team meeting and say it's not working. Turning the tables on the school system is very helpful. So when they say, well, but this is, we think we're offering free appropriate public education, and you're coming back saying, well, 6 times during this past week or 6 times yesterday, my child refused to participate. And then asking them, how, in your opinion, are you providing my child a free appropriate public education? What about this is enabling my child to make educational progress? I'm not seeing it. Because then they have to document it, and it gives you that prior written notice where they're supposed to explain the basis for their decision. So turning it around and asking them how they think they're providing a free appropriate public education puts the onus on them to explain the basis for their decision, rather than for you to keep saying it's not working, it's not working, it's not working. You've told them it's not working, you give them the data, and then it's up to them to tell you why they still think they're providing free appropriate public education.
So we have a number of other questions that have come in. And one question is about the IP team's decision to get an OT consultant that has not yet been done. And that was a decision made a few months ago. And the caller wants to know, how long does the school system have to actually get that done? And the fact that they have also not, responded or followed up.
Want to take that one, Megan? Sure. So we do know that many evaluations have sort of stalled during this period of remote instruction, although we have heard that a number of evaluations are being able to be done at testing centers now. And depending on the evaluation, there might be approval from different testing entities to be able to administer evaluations online. For OT consults specifically, the manner in which it's done would probably depend on whether it could be done accurately in a virtual method or whether it requires in person. And then if it requires it to be done in person, then it would depend on health and whether the district is performing evaluations in person. And if the district isn't able to perform evaluations in person, then you would likely want to look at doing requesting an independent educational evaluation, because different entities might be able to do evaluations that the school isn't able to do with their own staff. And if it's possible to have the evaluation done through another provider, then, sorry, I think I see clarifications coming in the comments. It looks like, yes, so this student is attending in person and has been attending in person for the last 3 months. So to finish out what I was saying, independent educational evaluations might be an appropriate request for a student who is still in the virtual model and hasn't been able to have their evaluations completed because the school district is saying they're unable to complete evaluations. For a student who is attending in person and requires an observational consultation like occupational therapy, as in this example, then I'm not seeing why the district couldn't do it. I guess you could still request an independent evaluation if the school is for some reason saying that their OT isn't on campus. But in this case, I would say if the district hasn't attempted to follow up on it, it would be appropriate to follow up with the IEP team yourself. You can reach out to an IEP team at any time to request follow up on an issue or to raise a new issue or concern that you're seeing. And so I would recommend following up with the IEP team and following up on the status of that request. And Leslie, if you want to go ahead and add.
Yeah, I don't have anything to add, except the one thing that I would say is that the law is clear, unfortunately, that if you want an independent evaluation, that you can't get one unless the team has done an evaluation that you disagree with. So one of the bases, we kind of used to think that if the team did not complete an evaluation they recommended, that you could ask for an independent evaluation at the expense of the school system, that there are some decisions holding that that's not a basis for asking for an independent evaluation. You can only ask for an independent evaluation to challenge an evaluation that's already been done. So I would agree with Megan that asking for an IEP meeting or writing to the school system to follow up and ask about the status of the evaluation would make sense. And then if it results in a decision to increase or change the services that are provided, to make a request for compensatory services.
So we have another question that came in. This was through Susanna, and it's about whether or not schools can provide speech language services via recorded sessions and not live sessions.
So I think that that goes to what we said earlier when we began. It's really going to depend on the individual needs of the student or students if it's intended for a group. So what always sends up red flags for me is if a decision is made, globally or for a group of kids without an individual consideration. So just recording, if the speech pathologist just records her sessions and that's it, and there's been no consideration of the individual needs of the children and whether that's going to be an acceptable, an appropriate way of delivering service, whether they can access it, whether they can benefit from it, then that's a problem. But it might be that kids can benefit from delivery of service that way. It's just going to really depend on their needs. So it might be okay, it might not be okay.
We have a question about a parent who feels the classes are too long and too many for their student with special needs, and what should they do?
So again here, and we're going to sound a little bit like a broken record on this, but the best advice would be to meet with the IEP team and discuss that concern with the IEP team, and discuss ways of meeting your individual students' needs, and tailoring the instruction in order to meet their needs and their ability to sustain attention, and the reasons that they're unable to attend to longer or more frequent sessions. Leslie, there was another question about if the district is asking for Medicaid, asking a parent to sign a form for Medicaid to pay for services that the school isn't, for the school to bill Medicaid, I think is what this question is getting at. And the parent is concerned about signing that form and using up an allotment of money. They've heard there are lifetime limits.
Okay, so that's a really great question. And in fact, yesterday or the other day we advised a family not to sign. So just for a little bit of context, the school system is the payer of last resort for services if they can find another source of funding under federal special education law. They're supposed to find that other source of funding. And for some of the services that they provide that kind of span education and medical services, some of the therapies like speech and language therapy, occupational therapy, physical therapy, case management, which the IEP team process is considered, those are services that Medicaid could be tapped to pay for. And it's called third-party reimbursement. So the school system can tap Medicaid benefits and then they get money back, which is potentially a nice source of income for the school system. Unfortunately, there's not a requirement that funding be used for special education purposes. So it's quite possible the school system could get a heap of money through medical assistance, third-party reimbursement, and then go pay for new athletic fields or whatever else they want to pay for it with it. That aside, the fundamental tenet, the fundamental principle of special education is that kids are entitled to a free, appropriate public education. And free means that it doesn't result in any expense to parents. So there was a lot of discussion when the third-party reimbursement requirement was put into the law about what that meant. So it means that you cannot be asked to pay a deductible. You can't be asked to pay for copays for services, But you also cannot be asked to agree to have your insurance tapped if it will result in a decreased lifetime benefits. This is generally more of an issue with private insurance, which is why none of the school systems will tap private insurance companies. But we also realized that there was a problem, and it's one of the reasons why there was a change in the law. There's a potential problem with tapping Medicaid benefits. And that is that if your child gets services outside of the school system, if you're getting private physical therapy or private speech therapy or other services, if the school system taps your child's medical assistance benefits to pay for those services in school, Medicaid's not going to pay twice. So our advice to families is always to be very careful before agreeing to allow Medicaid to be tapped. If their child is getting services outside of school, our advice is don't agree. And if you think that your child might get services outside of school, don't agree. The school system cannot deny your child services if you don't sign. This is simply a way to try to recoup some of the cost of serving kids, but they can't not serve kids if you don't agree. So if you have any concerns about, and there may be other reasons why families don't want to turn over medical assistance information to schools, you don't have to. It's purely voluntary, and you also can revoke consent at any time. So if right now your child's not getting services outside of school, but then your child does, you can revoke your agreement, you can revoke your consent, and the school system has to honor that. So, so no requirement that you do this.
We don't appear to have any questions in the queue right now, although if anyone watching has any questions, you can go ahead and put them in the comments. But I would like to take this opportunity to go back and elaborate on something I mentioned in passing earlier on in the webinar. I referenced that we had in a previous session talked about prior written notice and talked about meetings in which you might request that the school provide additional services to your student or different services to your student based on what you're observing during the virtual learning format. And so I do want to go ahead and just clarify for anyone watching that the prior written notice is a document you would receive after an IEP meeting, noting actions that the school proposed or refused if you requested something, and it should note the school's reasoning for proposing or refusing a different action. And so if you present the school district with a concern, they should respond in that prior written notice with your concerns and with their proposal of how to address that concern or their refusal for providing a specific service you requested, if you requested something specific. And when you receive that prior written notice following the IEP meeting, we would recommend that you look at it closely to make sure that they have documented your requests and all of your requests, and that they've documented their response to those requests, because the prior written notice will be your record of what was discussed and when it was discussed. And so in addition to that data that we're recommending you keep of what you're seeing in the home, it's important to keep a record of the discussions you've had with the school. And if something in the prior written notice, if you feel the notes or that prior written notice don't capture the discussions you had with the team, the requests you made, or their response, you can reach out to them and request that they make the appropriate edits, or that they attach your parent notes from the meeting to the IEP document as well, to make sure that it's kept with your student's record. And I don't see any other questions, Leslie, so I don't know if there are any last thoughts you wanted to add.
Yeah, I would just add to what you said that very rarely will the team agree to revise the minutes. Every now and again they will, but most often what they will do is, or what they say they will do is attach the parent's version to the minutes. So whenever, if your child's records are released, your statement would go along with the prior written notice and the team meeting summary. You do have a right under under state and federal special education law to challenge the documents. You could go to a due process hearing. I don't know of anybody who's ever used the due process for that. It is probably not a great use of time and effort when you can have your version attached to the minutes that the school system's produced. But it's a personal decision of how much effort you want to put into that. But we do, we will routinely ask that the minutes be revised, and then just as Megan said, if you're not going to revise them, then please attach this letter anytime the minutes are released.
We did get another question in the comments, Leslie. Can a school say they have to collect more data before they can evaluate a student when the parent wants to evaluate?
It depends how much data there are available. So I think it's going to depend entirely on the facts and what the assessment is, and what the situation is. I mean, the collecting of if it is a reevaluation and the team says, oh, we don't think we need to do evaluations, and you as the parent want your child evaluated, the team has to do the evaluation. And they can't say, oh, we don't know if we need to or not. Let's collect more data. If it's a reevaluation and you ask for that assessment to be done, they need to conduct it. I'm not sure, maybe you could provide a little more information about what the context is, and then I can answer this a little bit better. Is there anything in the...
While we wait, there's a separate comment asking what the specific wording is that a parent should use to get the school to bring someone inside the home to assist a child with virtual learning. Sort of to reiterate some of the discussions from earlier, there isn't going to be one specific wording to use for a request like this, because it's going to depend on the student's individual need. And so there's no magic words that will get one-on-one support in the home. The way to get one-on-one support in the home, in-person instruction, whatever the specific services that a student needs, the way to get it, rather than by specific wording, is by showing data and showing what isn't working, and asking the team to propose alternate ways of meeting your student's need, and having a discussion about whether whatever the service is, be it in-person instruction, someone in the home, a one-on-one, whether that is the way to meet that need. And so, like we've been stressing, keeping data such as, I'm physically moving my student into the room in order to do their assignment. I log them into the computer and they get up. They walk out of the room at this time and this time and this time. Those are the ways that you're going to show a need for a particular service, and you'll need to have a discussion with your student's IEP team to discuss what the need is, what strategies you've tried to meet the need, what strategies the school might try to meet the need, and whether the need must be met by sending someone into the home or bringing the student into in-person instruction.
I know that we've said before, but if you as a parent are spending all of your time essentially being your child's paraprofessional, having to be by your child's side at every moment of the day to sign your child on and to facilitate your child's participation, then that is evidence that your child needs a person, a live person to to assist or support the distance education. And then there's the separate issue of whether your child is able to, even if that live person is there facilitating, if your child's able to benefit from the virtual instruction. So we have looked at a couple of different options depending on our clients' needs. One is to have in-person support to access distance learning, and the other is in-person instruction, because both of those are possible. There are kids who can benefit from distance learning if they have a person with them all the time. And there are kids who absolutely cannot benefit from distance learning and need their instruction to be delivered in person. So those are not this, those are two different situations requiring a different level of person in the home. So, so being able to document your child's needs. But I think we will, keep coming back to, you should not be expected to be the person at your child's side every moment of their time. If the only way they can participate is if you are at your child's side every moment, facilitating their participation or doing their work for them, or logging them in and negotiating this whole endeavor, then that's, you should be documenting that, and that's an argument in support of having in-person assistant to support your child.
Leslie, the parent provided more information. I think you did answer the part about the need to continue to collect data, but the additional information was that there is data collected since no one can assist with virtual learning, and his yearly meeting is coming up, which there is no data, nothing to discuss. And then more information related to the fact that the parent cannot help him. She works 3 days, and the other 2 she's off, and she's helping her other son who has an IEP, and she has a total of 4 kids.
You want to jump in, Megan?
Yeah, just to reiterate what Leslie was saying, if the school is unable to collect data because they're unable to see your student, if your student isn't logging on to virtual learning, then this is where it would be helpful for you to jot down any attempts that you are able to make or what you are observing your student doing. You are not required to sit there and assist your student, but you are the one who has eyes in the home. And so you can create your own data log of what you're observing. And what we have also, another thing we've recommended is if parents can log a student on to their virtual learning in the morning, that will allow the school to at least collect the data of, student present and logged on, parent left and student exited, logged out of the virtual learning classroom. It will create, it won't be data about IEP goals or progress or skill level, but it would be some sort of record of what is happening when the parent attempts to have the student engage in virtual learning. And then Leslie, you also got clarification from the other question about the evaluation. It's a reevaluation, student evaluated privately 3 years ago, parent requesting OT services. Specifically, the student receives private OT and OT consult in school. The student has great OT needs, but the school doesn't see an educational need and want to collect data for a quarter rather than doing an evaluation now.
Okay, so the clarification is helpful, and I think my inclination would be to allow the team the quarter to collect the data, because if you've got a team that already says, that has already taken the position that the services aren't required for educational purposes, they're not needed, I'm not sure that doing an assessment right now is going to get you anything different than what you have already gotten. But if you are able to allow them some time to collect data, and you kind of can work out at the meeting what that data are going, what the data will look like. If as part of that data collection, you require or ask, or get the team to agree that the school OT will consult with the OT who did the evaluation privately, which is standard, to look at all the records. So looking at that private evaluation and talking to the evaluator, then you may get more in the way of the school evaluation than you would get if you pushed it right now. So what we sometimes often hear is that that what students receive privately is medical in nature. It's not educational. There's this distinction that lots of people make between medical and educational services, and that's not a particularly helpful distinction often. You think the way that I like to think about this is education is very broad. I mean, we know that it's defined very, very broadly. And special education is supposed to look at not just academic skills, but also functional skills. So when we look at functional skills in the context of school, we're looking at those skills not only that will support the academics, not only the skills that will help a child write or sit in the chair or move around the school building, but also those skills that will help your child be as independent as possible. Because the goal of education is to enable your child to be as independent a member of the community as possible. So thinking ahead and thinking about those skills in a broad way is important. And I think if you allow that data collection, you might get more than if that OT looking at things kind of narrowly just plowed forward right now. But that's just my opinion, and others might feel different. Anything you want to add to that, Meg?
No, I think that's great. We don't have any other questions in the comments right now, and it is approaching 7:30. So Leslie, the parent, said that that's great validation, and they can wait. And thank you. So yeah, there's no other comments or questions right now. I did include Susanna's email in the comments. If anyone has follow-up questions or questions about your specific student, you can reach out using using Susanna's email. I also included our main disability rights number as well. Leslie, any closing thoughts?
Yeah, so I would just say in closing that although she was unable to join us this evening, we have a new attorney with us for the next year. We received a grant for COVID-related education work. So Arthi Sidhu has joined us as of last week, and really you should feel free if you have issues involving your child to contact us, because we now have some more person power, and we would we want to focus as much as we can on COVID related work, and Arthi will do both individual cases and systemic and policy work. So we are thrilled to have her for this year, and this is, if you need our services, this is the time to contact us. So thank you all for joining us, and we will see you probably in, I think, 2 weeks. I think we're not going to do this every week, but we'll be back in 2 weeks. And meanwhile, keep your questions coming. And again, feel free to reach out to Susanna for intake if you need our assistance. So thank you for joining us. Thank you, Tasha. Thank you, Susanna. Thank you to Kelly, our closed captioner. Thanks, Megan. And we'll see you in 2 weeks.
All right. Have a good evening.